Maintaining the employment of a non-US worker has its own set of requirements. For example, I-9s you have to maintain for all workers, whether they are US workers or non-US workers. And you also have to update them. And again, I'm not going to get into an extensive detail. You need to look at the I-9 instructions and make sure you follow them. And if you have any doubts, reach out for competent counsel. You have to maintain H-1 documentation also on ongoing basis. Most lawyers, including our firm, when we process an H-1 worker, we give a detailed set of requirements that need to be um, complied with, and we have a kind of a pyramidal structure that we send to the employee and their lawyers. I'm sorry, the employer and their lawyers. So at the top of the pyramid, we will explain the very least that everybody wants to know. Then as you read more and more, you can get more and more information if you so desire. So in other words, we'll have checklists and then further explanation and then more detailed explanation. Sort of like a pyramidal structure of explaining how you need to do things. I have included in the handout links to I-9 compliance. Then there's something called E-Verify, which is a relatively new creature, a program for online employment eligibility verification. Ultimately, it will also cover identity verification. And I've also included a Department of Justice link to information, the Office of the Special Counsel, information on non-discriminatory practices. For example, one very common issue that used to occur was that employers were not sure if they wanted any specific kind of documentation. So I-9 will give you choices. The worker is allowed to produce A, B, C, or D. You cannot insist on C. You cannot say, I only will accept C. If the regulations say or the form instructions say A, B, C, or D, then you have to take whatever the employee can provide. Okay? Should alert you sufficiently to situations where you do need to get somebody involved to look at your practice or questions. Then for H-1 compliance, we've given you links to the Department of Labor's fairly extensive set of information for H-1 compliance. And the reason the focus is so much on H-1 is because these are the visas you will encounter the most in the workplace. Bear in mind, one of the rules that is probably common to all non-immigrant visa categories for workers is there should be no substantial variation from what was described to the government. So for example, you hired somebody as a software engineer and you want to promote them to project leader. Chances are you require some kind of an amendment. See, once the job has been described and it's described under penalty of perjury, government does not allow you to change the job incidents such as salary, description, etc. in a substantial manner. You have to file an amendment. Movement. If you move an employee from state A to state B, you will probably need some amendments in the paperwork. So, and the reason, think about it, the reason is quite simple. When you filed an H1 for Arkansas, for instance, the salaries there are for the same job is $45,000. You move the employee to San Jose, the salary there is probably $75,000 or $80,000. So now all of a sudden your obligation should have changed. It's kind of a good explanation of a good way of looking at it and remembering why amendments are needed. Note also that for H-1 workers, you can't bench them. You cannot just tell them, look, I have no work for you for the next month. Why don't you sit at home? There are strict rules, very strict rules that govern this area. See the H1 compliance link. Also see the attachments 2 to 7. There are some of the cases that arise from Department of Labor's jurisprudence, which means from the level of administrative law judge to the review board to the courts. So various areas of Department of Labor's jurisprudence.